Thank you all for taking the time to join us at the Unshackled Q&A with attorney Elysa. Elysa is a partner at Lodestone Legal, and we want to keep this AMA focused on talent visas as much as possible. However, we are gathered here today to answer your questions. So in terms of doing this in a more organized manner, please use the chat function that we have to start posting your questions, and we'll answer them as they come. And the question that I'd like to get started with is, a week from now, Elysa, there's going to be a change in administration. What impact would that have visas, green cards at large? Could you speak from your experience in the previous administration and shed some light there?
Sure. Again, this is from the previous administration, my work as an attorney during the first Trump version 1. I'm not 100% sure. I cannot be sure with 100% certainty what will happen during Trump version 2, the second administration. But what the first Trump administration did was really put a cog in the wheel of processing for all sorts of visas, including non-immigrant visas, and including immigrant visas. So administration issued a lot more requests for evidence, asking for more evidence about every sort of criteria under the sun. So you should expect, I would imagine this will be the case for Trump version 2. So I believe that under this administration, processing times, adjudication times will be slowed. Not necessarily there will be more denials, but I do think that processing time will be slowed, because I think one of the things that they want to accomplish is to slow down the administrative state and the administrative agencies. Now, the same is true for immigrant visas. If you are trying to apply for an EB-1 or an EB-2 or an EB-3, I think there will be, again, an uptick in those requests for evidence, not necessarily leading to denials, but just, again, slowing the processing time to make it harder for immigrants and non-immigrants to come to the country and either stay or stay temporarily. So that's what I foresee. I think in other categories that may or may not be applicable to the people on this call, there will be more deportations and raids, but I don't think that that's necessarily applicable for the people here, because you're all here, I would imagine, on some sort of non-immigrant visa, which will preclude you normally from being involved in that.
Thank you, Elysa. I'm going to ask a question. Could you talk about approval times for founders of O-1A visas? Can I start working for my company once the visa has been filed, or should I wait until the O-1A is approved?
Yeah, that's a good question. You cannot start until that is approved. So approval times for an O-1 is can be months, and if you file with the premium processing option, you will have which is an extra $2,805. The government is obligated to process your case by either issuing an RFE, a request for evidence, a NOID, a notice of intent to deny, or an approval within 15 business days. Now, that being said, at the beginning of this year, they have decided that they're not going to honor those premium processing timelines, because if there's too many cases to process within that timeline, and they will just reissue you or refund you the money that you paid. But usually for the O-1 category, it should be months or 15 calendar days, depending on whether you want to apply with premium processing. But no, you cannot start on the O until it is actually approved. It is not like other categories where there's any sort of ability to transfer and work on a receipt. That's not happening in the O-1A category.
Thank you, Elysa. Manoj asked, will I qualify for the remuneration category if my salary in my previous position was at the 90th percentile, but my new position is $10,000 less than the 90th percentile range?
Yeah, that's a hard question to answer without knowing the specifics of your case. The remuneration category, it matters so much on the specifics of your case, where you live, what you do, where you do what you do. So it's really important to speak with, your own attorney as to how you want to strategize that, because that's really is case specific. Another thing with remuneration category is it's actually a very hard criteria to meet. Because you have to show a lot of data regarding where it is you live, what kind of occupations, or what are similar people in your occupation in the certain area that you're living making, what is those percentiles, what is the, and you should be able to provide data of specific wages in those areas. So it's pretty hard to actually make that particular or check off that particular category. And again, your question, it's possible. I just don't know the answer because I don't know much about you and your particular case.
Thank you. HP asked, can you work for companies if you're on the O-1 visa? I'll rephrase that question. Could you share some more insight into different ways or different types of O-1 visas? So the employer route as well as a self-petition route, and what is possible one and possible in the other?
Of course. I think that's where he was going with that. So I think you're right on the nose with that rephrasing, Nikin. So the O-1 is an employment-sponsored visa usually. So usually an employer will sponsor one employee for an O-1, and you would be able to work in a particular place for a particular company in a particular job doing a particular thing for a period of 3 years, renewable in 1-year increments. Now, there's another type of O-1 called the O-1 agent visa, and I believe this is why you're using the plural of companies. The O-1 agent visa allows somebody to work potentially for themselves and for other companies by asking for an agent or an employer to file for them as an agent. So you're able to work for different companies that are on some sort of itinerary in a similar capacity. And if you're able to show the USCIS that you have an itinerary of work for different companies and that you still meet the regulatory criteria for the O-1. So it's important that you find either an O-1 agent or an employer that is willing to have you work on an itinerary with different companies and other companies being giving the green light and the okay for you to work in that capacity. And then some people choose to start their own companies and work as an employee on that O. That would require somebody else within that company to serve as the petitioner so that you could work at that company. So there's a lot of really interesting strategizing that goes on in the O-1 context, and it's actually a pretty flexible category. The problem with that category is that it's a high standard for approval. So you need to have a lot of other regulatory requirements met, which is similar to what the EB-1A immigrant category is, as far as the judging the work of others, having original contributions, serving in a critical or essential capacity. I know I'm missing a lot, articles, having articles written about you or having written scholarly articles, being presented in the media, and having a high salary. And I think there's another one that I can't remember off the top of my head because I don't remember which ones I've already listed. But I hope that answers your question.
Thank you, Elysa. And a quick follow-up on that. So let's say I'm an applicant who's a recent graduate and I'm running out of H1B attempts in my OPT and the OPT STEM extension. And I have an employer who I intend to continue working for. So how do I position myself to apply in the O-1 agent route? So what additional pieces of evidence do I need? I'm already working on multiple criteria for the O-1. I'll have an employment verification letter from my employer. Are there any other pieces of evidence work-wise that I need to secure?
Well, it's always nice to show that you have served in a critical capacity for this organization. So they would be able to, you would ask that particular employer for some sort of letter to be able to show that you worked in a high level, or not even a high level, but in some sort of important level within the job. So that's one thing. You would also want to make sure that they're on board with, if you're going to be as an agent, filing through an agent, that they would be willing to be on that itinerary, which is a really important factor if you're not using them to file the O for you.
Thank you. Moving on to the questions. Shashank asked, hypothetically, if I receive the O-1 visa, but later I step down from my startup and take up a job, can I still remain on the O-1 visa, or does it depend on the employer?
Well, it's hard to know the answer to this. I'm assuming you're getting the O through as an agent for your own company. If you get a job with another company, you are effectively doing what's called a change of status. So let's say you file for the H1B lottery and you get the H1B. Your employer would be doing either a change of status from that O-1 while you're in the United States, so it would change status to an H1B, or you'd leave the United States and come back as a consular processing and come back in H status. If you do that, if you're fired or laid off or decide you want to quit, you need to file another O to get back in that O status. You can't just pick it back up. It's just because you've changed that status from one to another. You need to notify the USCIS or depending the consular post that you have changed back to another status. So you can't just pick it up, unfortunately. Wish you could.
Thank you. Gia asked, what are some common judging rules and organizations you have seen clients use for EB-1A applications? Any key tips for presenting evidence for this criteria?
Yeah, this really depends on what particular area of expertise you are going to be claiming in your petition. Generally and traditionally, although traditions have been changed, they're going by the wayside a little bit in 2025, but generally the judging criteria has been contemplated as peer-reviewed journals and publications, because it was over and large for academia. And obviously that is changing right now. So you can think of many places. We've used hackathons in the past. We have used accelerators. And I'm thinking a lot of tech right now, but I don't, there's just a plethora of, you can be very creative depending on what particular area of expertise you have. And if you're able to argue it, if you're able to say, look, I'm an expert among my peers and I'm judging people who are looking to my expertise to help them make important decisions, or to help them discern expertise from non-expertise, you can make an argument for that particular regulatory criterion. Again, traditionally it has been journals of publications, but in 2025, we're seeing so many, this huge explosion of different professions. So you can certainly be creative, just as long as you're arguing that you have risen to the top of your peers and you are using your expertise in whatever area that you are of acumen to judge somebody's ability in some ways. So again, sorry I can't be more specific, but the long and the short is it's okay to get creative and in the medium that you're using.
Thank you, Elysa. So we asked, if I founded a nonprofit organization, does that evidence count as original contribution? And if I hosted a hackathon within that same nonprofit, does that count for judging? Any specific measures to keep in mind?
This is a hard one. The nonprofit organization is probably, all right, you need to go back to the idea, and this is general. This is how I go about processing and analyzing whether something may or may not qualify. Because again, I don't 100% know. All these situations are completely different. So if you think about a nonprofit organization, the first question you have to ask yourself is, what is the contribution to the field? What does the nonprofit do to the field? What does the field mean? The field means an entire realm of thought. For example, let's say you're doing a nonprofit that feeds the homeless. Okay, so the field is helping the homeless, right? Maybe, perhaps. And so you have to figure out, all right, by starting this nonprofit organization in Albuquerque, New Mexico, that's just where I'm from, so that's why I said it. How does that help the entire field? And then you'd have to make that connection. So for me, starting a nonprofit organization in one small town or a big town is not necessarily going to pass muster as a complete, as an original contribution to an entire field. Now, if you started a nonprofit, the International Feeders of the Homeless, that reached every single country in the globe, now that's a different story. That helps the field. And so again, it goes back to this very specific set of facts and circumstances that I'm able to say yes or no to that particular question. Assuming that it's a state, not a small nonprofit within a state, I would say no. But again, I don't know the answer to this question unless I talk to you specifically. So I guess, yeah, in that particular scenario, I can't be much help. But that's how I go through these process of analyzing specific fact patterns to see whether somebody would qualify for one of these categories or not. The other question is a hackathon. I think hackathons within a nonprofit, within a small state, it's questionable, right? We use hackathons every day, and sometimes they pass and sometimes they don't. So again, it really is about what is that hackathon? What is the caliber? What is the scope of that hackathon? What is the object of that hackathon? I know there's a lot of high school hackathons. That's certainly not the same as an international hackathon. Again, all things to take into consideration.
Yeah, thank you. Pranjali asked, my company won't be able to sponsor my
Oops.
O-1. Say that again. Could you please say that again, Elysa?
Yeah, we skipped one, but that's okay. We can cut back to him.
Okay. Pranjali asks, my company won't be able to sponsor my O-1. Is there a way I can sponsor my O-1? If yes, is it more difficult to get when compared to the employer applied O-1?
Yeah, so technically O-1 is not a self-sponsored petition. I want to make that clear. However, you can start a company and have someone else help you, i.e. a co-founder or someone from the board of directors, be able to sponsor your O-1 for you. Again, you can also go that agent route, which you would need to apply through an agent or the employer as your agent. So It's not necessarily more difficult. It's just more things to think about because you have to figure out how to set up your company, find a co-founder or someone on a board of directors or somebody else that can sponsor you because you are not technically able to sponsor yourself on an O-1. I'm sorry, your company is not able to sponsor the O-1 for you. So, yeah, that's really the only other way to go about it.
Thank you. Parker asks, what's the pulse on increasing number of EB-1A applications as the new administration is about to come into the White House? And there's another part of the question, which is how does this impact people from India?
Yeah, so I think everyone is applying for EB-1As and everyone is applying for EB-2 national interest waivers. It's not just from India, but for people from India, it could slow down the processing of that EB-1 category because all of these numbers are based on some algorithm that I don't understand about the number of total visas that are allotted through all the employment-based categories and through all the different countries of chargeability. So if there's a significant uptick of people applying for an EB-1A category, that means there might be a slower processing time for visas because there's only a certain number of visas available for each category, which means that you might have to wait longer and even in that category for your green card. It's just the way it is. I think that's going to be something that we're going to see across the board in all of these categories, unfortunately, because, well, we all know why, because there are more people applying for visas, there are more people applying for EB-1A visas, and there's only a specific number of visas allotted for each particular employment-based category from each country of chargeability. Yes. Another thing that's been happening with the EB-1As in general, as I mentioned in the beginning of this call, is that everybody and their mother applied for an EB-1A and a national interest waiver in the months of November and December in anticipation of the change of administration. So they are issuing, well, they're not necessarily issuing extra RFEs. We don't know that yet. But they have stopped honoring the premium processing, which means that even if you filed with premium processing, they're saying, I'm sorry, we cannot process this application within 15 business days. We will refund you the money once we do process it. So we have many applications right now that are experiencing that. Which causes trepidation among people who were scared anyway and filed their applications with premium processing before January 20th. So there have been a lot of repercussions and things already happening within the USCIS even before the Trump administration has begun. I'm not sure if I answered your question, but I don't think that it has anything to do with, I think the slowing down of visa processing in the EB-1A category doesn't really have anything to do with the Trump administration itself. It has to do with the fact that there are more people applying for the EB-1A because the allotment for these different visa, a number of visas in each category has to do with congressional act. It does not have to do anything with what Trump can or cannot do on his first day of office. So I hope that helps.
Thank you. Prakhar asked a question. What's the impact of working as a mentor in NPO and the organization is funded by the US federal government?
I don't have any more context than that. Are you talking for the EB-1A category? Should I assume that?
The previous question was on the EB-1A category.
Okay, sorry. It's good. We, again, very specific question. Would need to know a lot more context. I need to know what you're doing. I need to know a mentor for what, for who, and what scale. What populations are you helping? These are the questions that you really need to strategize with your attorney on. Unfortunately, again, I can't answer that specific question because I don't know the details, but on a general level, those are the questions I would be asking. What is the impact? What populations are you working with? What are you mentoring these, and who are you mentoring? All of these questions come into play in assessing your ability to have an EB-1A successfully filed for you. And also what even criteria this would hit under the EB-1A category.
Thank you. Rama asked, when should a founder contact a lawyer to start building an O-1 visa case? What preparations or documents are needed beforehand? And how long does the filing process typically take?
Yeah, I think if you're thinking about founding a company and you need immigration, non-immigrant status, you should contact an attorney to strategize. Sometimes building an O-1 takes a long time. So can take, 3 weeks or 3 months, depending on the legwork that needs to be done. Have you started your company? Have you incorporated? Do you have a co-founder? Do you have somebody else that might be able to file the petition for you? Those sorts of things are things to be taken into consideration. Other things to be taken into consideration are, can you meet the regulatory criteria involved for the O-1A category? You might need to work on building your resume in anticipation of filing an O-1, which is something that's really important and can take a lot of time. Once you've decided, all right, I'm going to do this O-1, you've contacted your attorney and your attorney says, great, I think you have what it takes. Then they will give you a list of instructions of things to find. That can include your transcripts and education diplomas, not because that is in itself a regulatory criteria, but I do think that it lends credence to your application depending on your particular area of expertise to have an education, because the regulatory criterion contemplates that you have risen to the top of your field, and in a lot of professions, an education is one indicator that you have. You'll need to have a good resume that enables your lawyer to look at your accomplishments and be able to quickly assess and determine what it is you might need for a better case. The other thing that happens is that we have to start, or you would have to start collecting letters of recommendations, or what I call expert opinion letters, from people who are your peers that can attest to your specific accomplishments. This takes a long time, or it can take a long time. And they need to be from people who are not necessarily biased towards you, i.e. they're not your best friends, they're not your neighbor, they are professional peers who can attest that the work and the accomplishments that you have done that has made you rise to this extraordinary level within your particular field. You'd also need to narrow your specific field to a very specific niche. So if you're a software engineer, you shouldn't say I'm a software engineer, because there are billions of software engineers in this world. It's really hard for you. Well, maybe not, but I would argue that it's probably going to be pretty hard to argue that you have risen to the top of your field. But if you are an expert in data privacy on, I don't know, I got to get a little skinnier or more narrow than data privacy, but we'll go with data privacy on large systems. I'm sorry, all you tech people, I said that probably incorrectly, but that's a lot more specific. And so there's a better argument for you to be made that you have risen to the top of your field. So you really want to narrow it down to your specific niche so that it's easier to argue that you have you've worked at the top of your field. Once you've done that, you should think about all of the really great, cool, important things that you've done at your jobs, in your lives, in your career, at your schools, that have really made you stand out against the people that you've worked with or the people that you've competed against, because that's what you're going to be describing in your letters. And you really need to go into really great depth and specificity when describing them. And then you should have your lawyers look those letters over, and they will tell you to be more specific, because you really need to be specific. And that's the hardest part of the O-1, I would say. The rest is really just documenting your other accomplishments. Have you peer reviewed for something? Have you been the judge of a hackathon? Have you written articles? Have you appeared in media? Those are the sorts of things that are going to show that you have risen to the top of your field. And then once it's filed, again, it can take 2 weeks if you file with premium processing, or 15 business days, not excluding federal holidays. Or it can take months and months if you decide not to file with that premium processing option. So there's a lot to think about with an O-1. I would start, if you're going to take your case to a lawyer or to anyone, to have a really good resume that documents everything you've done, everything you think that could be used, because that will help us be able to show you where the gaps are in your case.
Thank you. Prakhar asked a question. Do we go through any interview in the EB-1A process, pre or post approved?
That's a really great question. So in the EB-1A process, it's a 2-step process for the green card. The first is obtaining that I-140 immigrant petition based on your extraordinary ability. In that particular part of the process, there is no interview. There's just filing by paper, answering by paper, you get an approval. Now, once your I-140 is approved and your priority date that comes on the I-140 approval is issued, when your priority date is current, you can apply for adjustment of status. That is the application for the green card. In the past, and presently, there is no interview for that EB-1, for that adjustment of status application. Now, I want to be clear. This is a 2-step process. Step 2, the green card process, is linked to step 1, that EB-1A, that I-140, and you've gotten that through your extraordinary ability. I want to be clear, they're linked together, but they're not the same thing. So once you've gotten your I-140 approved, your priority date is current, you're able to apply for adjustment of status. You have to prove to the officer that you are worthy of staying in the United States and getting a green card. You have to give them lots of information. You have to give them a lot of documents about your immigration history. You have to tell them a lot of things about whether you have been in the Communist Party, have committed any crimes, have entered without inspection. There are 3.5 pages of yes or no questions, and you have to answer them truthfully. And then at the end of the day, until recently, there have been no interviews at this stage of the process for employment-based categories, including the EB-1A. However, in the past, there have been. And during the Trump administration 1, there were interviews for EB-1 categories, or any EB categories. So if you have a perm, if you have a perm-based I-140, a national interest waiver-based I-140, and EB-1A, EB-1B, EB-1C, you all had to show up at your adjustment of status interview. Now, right now, the Biden administration, actually, I don't know if Trump changed that at COVID. I think he changed it at COVID. I don't remember. There were no more interviews, but that is not to say that the Trump administration will not change it so that there are again interviews at the adjustment of status stage of the process. So that is something I anticipate, because it's another way to slow down the processing of immigrant applications of green cards. And so I do expect that he will change policies so that EB-1A adjustment of status beneficiaries will have to go for an adjustment of status interview. And during that interview, they will ask you all of those questions, those yes or no questions, to see if you're answering truthfully. They will also want to know about your employment, or if you are a self-petition or like under the EB-1A category, what you are planning to continue to do in the United States as the recipient of an EB-1A immigrant visa petition. So that was a really long way of answering your question that yes, I anticipate that you will have to have an interview at some time in the future under the EB-1A category. Sorry for being long-winded there.
Appreciate the detail. I need to travel outside the US on Jan 20 for a speaking opportunity. Do you think Trump's J1 executive orders affect any travel for legal immigrants?
I don't anticipate them affecting legal immigrants. Yeah, I don't really anticipate that at all. Make sure to have your documentation handy. Make sure your passport is valid for at least 6 months. Otherwise, they will shorten your I-94 to the expiration of your passport, and you don't want that. But I think besides that, you should be fine if you're in valid non-immigrant status.
Thank you. Benjamin Smith asked, is EB-1A an auto green card? I think you just answered this in your previous question.
Is it an auto green card?
You automatically get a green card with an EB-1A approval.
Correct. Oh, there it is. You did. I did just answer it. It's a 2-part process. First, you have to get the non-immigrant petition. I'm sorry, the EB-1A I-140 approval. And then you have, i.e. you have to prove that you warrant a green card, an immigrant petition, based on a particular category. And then at the step 2 part of the process, you have to prove that you are eligible to come to the United States because you have not committed or you have not violated what's called a ground of inadmissibility. So it's a two-part process.
Thank you. How many media articles being published is good enough for the media criteria?
Oh, that's a hard question. I don't know. The more, the better. 1 is okay, but probably not enough. It depends from officer to officer. I think that this is a very subjective application. And so one officer's, yes, that's great, is an officer's no way, Jose. I think the best you can do is get a media attention in a media publication that is well known. And the more of those, the better. The regulation contemplates major media. Now, lately, you can argue that a smaller media company constitutes that, but you have to make the good argument. Anyway, the question is a hard one. I don't have a good and fast rule for how many. I've argued 1, and it worked. So it's just a matter of how you argue, what you argue for that particular criteria.
Thank you. Manvendra asked, my F1 OPT is starting on 3rd February 2025. Can I register my company now? And what are the things I can't do till then? And how to track my... So Manvendra's question, just to rephrase, is around, he's about to graduate and start, or he has already graduated and he's about to start his OPT period. When should he incorporate his company, and what are the things he needs to be aware of?
So I'm assuming you want to be starting, you want to work for yourself on a F1 OPT. I think that's, yes, am I assuming that correctly? If I'm assuming that correctly, you need to have a business incorporated because you need to show that you are paid by the company. The OPT context is not as stringent as the STEM OPT. So you're able, as long as you get a paycheck by the company, you should be fine. You also need to be careful of being unemployed for a certain amount of time because that's a very important thing to take into consideration when you're on F1 OPT. So what is the date of your graduation and the number of days that you've been employed before you start work at your company. But the company needs to be incorporated and you need to be receiving a paycheck from that company. So that's really as specific as I can get on this particular question right now. And what are the things I can't do till then, and how to track your hours? I don't understand. You can't work until February 3rd, 2025. So you won't be able to perform work when incorporating your company. So that's important to know. And how to track your hours. I don't understand. You mean for OPT? I'm sorry, I don't understand that question. So, but I think I've answered the majority of it for all the
Thank
things
you.
that are important.
Uma asked, since it looks like the O-1A is going to take some time, she's speaking from a startup perspective. Can I transfer my H1B visa? So she currently has a H1B visa to my new startup, but she's a solo founder of that new startup.
Yeah, so you need to show an employee-employer relationship. So you need to be an employee of the company. The company needs to be incorporated correctly so that you are an employee of the company. You can still do it, but I'm not a corporations attorney, so I don't know how to set up the company in the right way. But you would need to speak to a corporate attorney who would be able to help you incorporate the company in a way that you are also an employee of the company, to receive to receive a paycheck and to be the servant in this is a legal term of art, but a master and servant relationship, you would be the servant, i.e. the employee, and the company would have a right of control over you. So there needs to be a lot of things going on, even in your context as a solo founder. And with that, I would speak to a corporate attorney who can help you with that. But it's possible, is what I'm saying.
Thank you. Ritika asked, what evidence qualifies for having played a critical role in an organization for an O-1A?
Wow, this is a good question. The critical role is the regulation doesn't contemplate this. It's the policy manual that contemplates what a critical role is. A critical role it used to be a lot more narrow of a definition, but now it's whether you've played some sort of important role in the company. The role that you play, your title doesn't matter. It's about what you've done and how it's important to the company. This can be the bottom line. This can be to some product that you've built. This can be to some line of business that you have procured. All of these things are possible and in helping you fulfill that criteria. So what the key would be is describing in detail what it is you've done and why it is important. That's always the key. What I find with a lot of people is they don't describe this in enough detail. So you need to think about all the aspects of what it is you've done, describe absolutely everything that you've done, and then describe in the myriad ways is why it's important to the company. That is the key to checking this box on this particular regulatory criteria. Now, the other part that's often overlooked is the part that the organization must have a distinguished reputation. So there's actually two parts to this regulatory prong. Did you serve a critical role or leading? And did you work for an organization with a distinguished reputation? So both parts of those need to be fulfilled. And I'm sorry, O-1 is critical or essential. So you need to answer both of those in as much detail as you can. And that is the key to getting that particular regulatory criteria.
Thank you.
Sure.
Pranjali asked, how many LORs are needed? O-1 and EB-1A. Yeah.
Yeah. So my thought is 5 to 7. I think any more than those my strategy is in this era of RFEs, if you have too many letters of recommendation, if you get an RFE, you're not going to have anybody else to ask for a recommendation because you've already asked them for your petition itself. So even if you want to ask 20 people, I recommend 5 to 7. That's it. If you want to go a little bit more, 8 to 10, but you still need to have something in your back pocket as a strategy, because there's an uptick of RFEs, and the way we answer RFEs is by asking for more people to talk about you, or that's one of the ways. So I would start with 5 to 7, or let's say 6 to 8. And then if you need more, reserve those for the response for your request for evidence. That's my particular strategy. I think more than that is unnecessary. Unless there's a lot of things to say about you. And in that case, great. More is okay.
Thank you. Rishi asked, how much of a help does social media presence and influence provide in an NIW and EB-1A petition?
Yeah, that's a really good question. You're asking an old person who doesn't really rely on social media a lot. But I will say, depending on your particular case and depending about what area you're in, it could definitely make a difference. I think because adjudicators are old like me, we need to have someone connect those dots for us. But I think it's possible. Again, it depends particularly on what area of expertise you have and what you're trying to claim with this particular social media presence. It wouldn't check the box for media. And that is for now. That could certainly change because immigration does change a little bit with what they allow. And it is possible that in the future, near or far, they might consider social media as considered as media, depending on the followers you have or that's right, followers. Is there anything else for social media? The viewership that you have, it could change. But for now, we'd need a lot of connecting of those dots. How much time does it take to get the I-140 in current times? Oof. So this is a really sad question. Assuming you're from India, it can take a really long time if you are in the EB2 or the EB3 categories. There are people that have been waiting. Well, there are people that have, and I hate to say this, but I have to be honest. There are people that came here on F1s, got their H1Bs, had children, and their children are now 21, and they're still waiting for their green card because they've got either an EB2 or an EB3. Even on the EB1, people that filed their petitions in 2016 are finally just being able to apply for a green card. So it really is taking a long time. And I'm sorry for our government and for our immigration system on behalf of everybody who's trying to get their green card, because it surely is unfair for people from certain countries. So yes, it's taking a very long time, which is why so many people are interested in trying for that EB-1A category, because for now, it's taking less time than the other two categories, the EB2 or the EB3.
Thank you.
Sure.
Surubi asked, are we able to apply for the EB-1A if an individual is outside the US but qualifies for the criteria?
Yes. As I stated, the green card process is a two-step process. There's the immigrant petition, and then there's the application for the green card. So you can apply for the immigrant petition either inside or outside of the United States. If you're outside of the United States and you have an approved I-140, then when your priority date becomes current and you're outside of the United States, you can do what's called consular processing. It's a different but related process as the adjustment of status application, which you do when you're in the country. So if you're outside of the country and you apply for that I-140, then you will eventually consular process outside of the country and then come into the country on an immigrant visa and obtain your green card. If you apply for your EB-1A immigrant petition inside the United States and you remain inside of the United States, then you apply for your green card based on the adjustment of status application, which is really adjusting your status to that of a green card holder while you're in the United States. So yes, you can.
I have a quick follow-up question to that. So,
Sure.
Surabhi here. So let's say the EB-1A application is approved and I-140 date is current, like the priority date is current. Does that mean the individual now has to fly in the United States to apply for green card and then stay in the country until that process goes through? The
So-
step 2?
If the EB-1A is approved in the United States and the person is in the United States,
Outside the States?
outside of the States, then they would stay outside of the States and consular process.
Got it. Okay.
They would go, I don't know what status you're on, but if most people to get their visa to come into the United States have to make an appointment with the consular post in order to get their visa stamped or issued and stamped. It's the same, it's a similar process for the adjustment of status application. I'm sorry, for the consular process application for your green card outside of the country. You do it at the consular post.
Thanks.
We are almost at time, everyone. So we'll take another question or two.
Okay.
So Surendran asked, can I stay in the USA if I apply I-140 to EB-1A and it got approved and my current L1 H1 visa expired?
This is a wonderful question, and I think it's one of, I wish we had a little bit more time. I can stay on if you can so that I can answer this. This is one of the most misunderstood questions. The answer to that question is no. Your L1 or H1 visa, any visa that has a letter on it, we call it the alphabet soup of non-immigrant visas, it's a non-immigrant visa. It allows you to stay here for a certain amount of time. Now, parallel to this process is the immigrant visa process. So we have your L1 or H1 or F1 or your B1. That's a non-immigrant process. You have to maintain your status on this process to stay into the United States. Now, a lot of these visas, not all, well, all of them, can also decide, you know what, I want to stay here and apply for my I-140. Well, not all. There's a lot of nuance in this, but let's say on the L1 and the H1, which are dual immigrant visa categories, you decide you want to apply for that I-140 immigrant petition. You do so, that's perfectly fine, but it has no bearing on your ability to stay in the United States while you're applying. Even after it's approved, you still must maintain that non-immigrant status during the whole course of your stay here, even if you have an immigrant petition approved. It's very important that you understand that. The EB-1 categories, any of the immigrant categories, do not confer status. They confer nothing but the ability for you to eventually apply for your green card when your priority date is current in the country of in your own country of chargeability. Even if you have an I-140 or an I-130, you need to maintain that underlying H1B or L1 or whatever status that you have. Otherwise, you will be considered out of status, and that can have potential severe ramifications. All right, well, I hope that helped.
Okay, so
Yeah.
are you at time or do you have a few minutes?
I have a few more minutes. I've got to eat dinner eventually, but yes, I have a few more minutes.
Amazing. I do have to jump, so Amulya can take over hosting, but let me just cue in the next question, which is Ajay asked original contribution for business.
Sure.
Are contributions in your previous employer as well as your present employer considered for the EB-1 in the original contributions criteria?
So usually for a company, your contributions are for the company. So they wouldn't actually, and to answer your question first, it would be for present or past. It's okay for whatever. You can use present or past contributions. But if they're for a company, it would usually fall under the critical or essential role or critical and leading role criteria rather than the company, because you're creating something that's important for the company, not for the field. So again, that's something that you'll need to talk to your attorney about in order to figure out whether that's actually an original contribution to the field of endeavor for your field of expertise, or if it is, or sorry, my dog is barking over there, or if it's a critical role that you have contributed to a particular company. But both present and past employment is fine. All right, I'll answer just a couple more questions and then I think it's time to go. For LORs, do we have to get the recommendation letters from people in senior director VP letter, or could it be from anyone who I've worked with? It's better to have someone from a higher level. Because again, we need to remember what it is we're talking about here, what it is we're trying to prove, that you are an expert amongst your peers in a field of endeavor, not you are an expert among your among your coworkers in your job. So if the VP at a company can claim that you're an expert in a field, it carries a lot more weight than if in your, I don't know, your senior manager at your company does. So we always have to think about the weight and the credibility of the people that are authoring these letters. I'll answer two more questions. Will the EB-1A become a lot more difficult in 2025 as the number of applicants have increased? If officers just see more applications, they might give more denials. Both is true. We have talked about this earlier. If more people apply for EB-1s, there are less visas to give at the end of the day. So it's not necessarily that they'll be more difficult to get, but it might take longer for the priority dates from the EB-1A category to be current. And also, I guess that was not your question, so now I will answer your question, which is, will it be more difficult? Time will tell. I think the policies within the USCIS will change. What the trends will be, they've always changed. They change every month, so maybe not every month, but they change a lot. So it's in a definite state of evolution always. So I do foresee it becoming harder as more people apply for them, unfortunately. And they definitely will be giving more RFEs, and I don't know about denials. Definitely more RFEs though, unfortunately. So it's very important to have a very well prepared case. And the last question is, do podcasts count for media? Yes. You need to document the podcast well. You need to document the podcast is a source of major media. You need to argue that the podcast has an X number of subscribers. And then it definitely could qualify as media. And it has in the past. I've used podcasts on a number of occasions. All right, guys. Well, that was great. I hope I answered a lot of your questions. And we have these every couple of weeks, I believe. So if I didn't answer your question tonight, we can answer them in a couple of weeks. But it was great talking to you all, and have a really good night.
Thank you so much.
Thank you.